Okay, good morning, everyone. This is another segment of our business law class. Today, we'll be looking at employment contracts. So, one interesting thing is after school, the next for you is to get a job. And I'm sure that you are doing this ICAN of a thing so that you can get a good job also for yourself. I'm quite sure of that. So, at your level, I wouldn't say you are under any employment, but it's possible that we have some of you working and, and schooling at the same time. This topic is very important and it is highly examinable. When we say employment, what we mean is that job. That's just a simple way to put it. To have employment means to have secured a job. That's what it means. But interestingly, it is possible that the job we are doing, they give you a letter to show that you are appointed. It is possible that because you know somebody that knows somebody, they just ask you to come and resume. There is no letter, but there is an oral word to say, come and resume next week, Monday. Take my word, and you start. The boat is still what employment. So employment contract can either be written, that is an express employment contract. It could also be oral, based on understanding. But what is important is an employment contract is a voluntary agreement between a master and a servant. The master in this case is called the employer, and the servant in this case is called employee. Where the employee, for a monetary consideration or remuneration, promises to render a service to the master. Now, two things are involved in an employment contract: the employer and the employee. The employer pays employee to carry out a service for him or her, and that is the solid interpretation of employment contract. Now, in the conventional work environment, an employment contract is expected to have rules and regulations, rights and responsibility, duties and job requirements expected of an employee. So let me bring it down to a layman term called offer letter. For me to say that I've secured a job, I needed to be given what we call offer letter. The offer letter will specify my job description that we call JD, the remuneration that we call my pay, and the job, work condition, and environment. In a nutshell, an employment contract is a binding contract between the employer and the employee. I hope that is clear. Do you have any question in this regard? I'm trying to tweak my explanation because you are not working. If you are working, you are just partially doing maybe a part-time job. So that's why I'm not giving you too much of terms here. For those that are working, I can go into further details. But what you should know, just like we have on our slide, an employment contract can either be formed expressly by written, can be formed orally by vocal. Now, what is important is that an employment contract is a voluntary agreement between a party called employer and a party called employee. The employer pays the employee for service rendered. Is that it? Now, at this level, we also need to understand that the relationship between the employer and employee is what we call servant-master relationship. What did I call it? Servant-master relationship. It is important that you know that. Okay. think you are still seeing my screen, right? So I've
So we can
explained
see
this.
your screen.
Okay, good. I've explained this earlier, forms of how we can form an employment contract. It can be formed through a written document. It can be formed like you can enter into it orally. But it is important that an employment contract that you want it to be valid anywhere in the world, it has to be through written. The contract employment or offer letter is the binding agreement between the employer and the what employee. Now we have it said that there is no particular form required for contract of employment. It can either be oral or in writing, right? But I mentioned that it is important that you make it to be what in writing because of future reference. Is that clear? So we also appreciate that in the private sector, the term may be in a written document executed by both parties or in the employee's letter of employment, right? Remember, employee letter of employment I mentioned earlier will show the job description, the working condition, the remuneration which involve the salary, the pension, and other deduction. And also in the uh, offer letter, it will also show the termination notice, when and how you can terminate your employment. And it will also specify, should there be a misconduct, dismissal summary will also be specified. So it is always good to enter into an employment contract that is expressly written, so that if there's any breach of contract, the aggrieved party can sue for damages. Now, what are the tests we need to take into cognizance for us to say, okay, there is a contract of employment? So for your exam purpose, you have three major texts that we take into consideration. Now, they are independent of one another, meaning that if any of these exists, there is employment contract. But the most valuable test is the what we call control test. The control test is the popular saying, he who has power to hire has power to fire. Have you heard of that statement before? He who has power to hire has power to fire. Yeah, so that's what we call
No,
control
sir.
test. So the objective of control test is to establish a degree of control between the employer and the worker. That is between the employer and over their worker, that is the employee. In this case, the employee are seen as servant to the employer. They are so loyal to their employment so that they follow strictly and religiously the rules specified by their employer. As a matter of fact, if it is a married woman that is in a contract of employment and there is a control test, you will see that if the husband say, don't leave your house by 6 o'clock, and the office said that you must resume office by 7 o'clock, and the wife is staying on the mainland, her work is on the island, the wife had to leave the house by, let's say, 4. Meaning, in this case, the wife, because a high level of control, he will not want to disobey his boss. So we can always discuss the issue at home later. But this boss, there's control. You always want to follow because the boss that hire him or has power to fire him without any explanation. Although that does not make sense. When we get to dismissal, we will appreciate more of when is the best time to dismiss and what are the procedures involved. Now, control test in summary is explaining that for us to say there's employment contract, there must be control that exists. And what is that control? The employer, the boss, the master, the company here must have control over the person they employ, that is the worker, the employee, or the servant. But in the case of independent contractor, that is not the case. An independent contractor most of the time carry out what we call contract for service, right? Because he's independently to work on his own, the control is very, very minimal. Now, there's what we also call integration and organization test. For integration and organization test, we are considering how integrated the worker is into the employer's business. You know that there are some workers that if they do not exist, the business as a whole will not exist, right? A very good example are the labor. For instance, in a construction business now, you will need a lot of bricklayers, a lot of laborers to work for you, right? You can actually hire them directly or indirectly. Where you hire them directly, you have control over them, right? And because you hire them directly or indirectly, without them, you cannot do any construction. Am I correct? It means such workers are integral part of the business. Now, economic reality test. So under this test, we are looking at the substance over form. So the course will help us to look at all elements of the contract to decide whether a worker is an employee or an independent contractor. So we have instances of businesses. For instance, a doctor, a medical doctor now, some organizations don't have absolute power to bring them into full employment. Rather, they will see them as what? Consultants. In that regard, the economic reality is that such employers are working for the business, but the business are not, the company is not in full control over them. So a lot of things will now vary. The pay will vary. What are the opportunities they have other than pay, like pension, health benefit, and every other thing? So economic reality just want to bridge the gap between saying there is a control test or there is an integration test. What we want to see, the nature of the job is what we use to determine whether there is employment or not. A medical practitioner that is consulting for a particular organization, we can see that as what? Employment. And as well, we can see that as what? Contract or contract for employment, that is independent contractor. It's a function of the reality of what is happening. I hope that is clear. So the first two looks very straightforward, but the last one, we look at the reality to determine whether there is employment or not. As an employee, what are your duties? If you have been employed by an organization, certain duties are expected of you. Yes. One thing you need to do is to respect the offer letter. Yes. The duty to obey employer's lawful order. You need to employ the terms of respect the terms of employment. Now, the duty to exercise the professed skills and diligence. Of course, the reason why you are being employed is because of your knowledge, your skills, your experience. You must exercise that. You must show that, yes, they hire the right person for the right role. Now, duty to discharge your duty with all full responsibilities. Here, the duty to do duty for which is employed or other related duties. The reason why you are being employed, you must carry out that function. We have instances where employer can actually delegate other functions to you. It is a fiduciary duty that if it is within the employment, you should please do that function and do not delegate. So duty not to delegate is a duty expected of an employee. Duty to serve the employer faithfully. The duty of an employee is not limited to what we have here. There is a duty not to make secret profit. It's also a duty of an employee. If you are in charge of sales, you are supposed to make full profit and disclose it. It is your duty to do that. Even it is a duty of you as a salesperson to respect the company's customer. So it is not limited to the 6 that we have here. Please, do we have any questions? No.
Okay. No question, sir.
Thank you. Now, remember, under contract, when we are discussing contract, I mentioned various ways under which contract can be terminated. One of it is what? Breach of contract. In a layman language, breach of contract means two parties agreed to do something. One person is not doing his own part of the agreement. The person that is not doing his own part of the agreement has breached the what? The contract. I have mentioned earlier the duties of employee. Where the employee is not going by the rules, where the employee is not discharging his duty properly, then he has breached the duties. Now, what are the remedies available to an employee if any of the duties are breached? When the employee did not carry out his function very well, what are the available remedy to the employer, that is the masters, when those duties are breached? Number one, to intercept, to interdict where the servant has been involved in a criminal offense, or to dismiss. Of course, as an employee, you shouldn't involve yourself in a criminal offense. So the employer can decide to issue a disclaimer that is not involved. You are working outside their contract, or they can decide to what? To ask you to leave the job, dismiss you. As a remedy, the employer can also suspend the employee. We have this under Section 60 of the Labor Act that gives the employer the power to suspend the worker as punishment for breach of his duty or some defaults. Again, an agreed employer can also sue the servant for indemnity. He can sue the servant for what? Indemnity, in respect of any losses incurred as a result of servant negligence. To sue for indemnity, in a nutshell, simply means to sue to gain compensation. That's the simple term to explain it. Again, an aggrieved employer can also sue the servant in order to enforce reasonable restraint of trade. So we have instances whereby the custom of the trade allows us to enforce some certain rights. So you can also sue to enforce those rights. Don't forget, finally, he who has power to hire has power to fire. So duty, you also have the right to fire or to disengage or to dismiss the servant without formalities. But then it is always good to follow the what? Formalities. Any question? Any question? So
No,
we have
sir.
looked at the duties of an employee. Where an employer did not carry out his duty appropriately, the employer has certain rights over him, right? And those rights have been explained. Now, let's go to the next slide. As an employer, what are your duties? What is expected of you as an employer? The first thing that is expected of you as an employer is to provide work. Is to what? Provide work. Because if you are employing me, what are you employing me for? To come and do something, right? So you must what? Provide work. That is very important. Number two, in as much as I'm doing the work, what am I entitled to? Wages and salary, right? So it is the duty of an employer to pay wages or remuneration as we have it in the what? Offer letter. An employer also have the duty to provide written statement of the terms of employment within 3 months after the servant has assumed duty. Well, this one is not really applicable in Nigeria. Before you even resume work, you must have received the term of your employment, because it is the terms of employment that we call here offer letter. So I cannot resume any work without what? Offer letter. Now, another duty of an employer is duty to provide a safe work environment or a safe work system. We can also look beyond these four major duties that I've mentioned there. Now we think again, what should be the duty of you as an employer to your employee? We talked about duty to provide work, duty to provide a safe work environment, duty to pay remuneration, duty to provide offer letter within 3 months after the servant has assumed duties. What are the other duties that come to mind? Anybody? Anybody? Okay, now under the Nigerian regulation, employer with at least 5 staffs have the duty to do statutory deduction on them, to make statutory deduction on them. Very key. So that is also one of the duties that is not mentioned here. Now, dismissal. What do we call dismissal? Dismissal simply refers to as removal of employee without formalities. So when an employee is being sacked or is being asked to leave the job by the employer without formalities, we call that what? Dismissal. At various levels, we have different meaning to dismissal, but here is what we mean to be dismissal. Now, dismissal can be effected in any of the following ways. Act or conduct likely to bring the employer into disrepute. If an individual carry out a function or is acting not in accordance with the organization policy, they can decide to dismiss him, especially where his action can put the organization into disrepute. Where this servant practices or conduct expose the master to loss of public interest, this also can lead to what? Dismissal. Gross immorality. What we have in offer letter is for gross immorality and gross misconduct, they will always specify what they mean by all of those things. For instance, if you are caught harassing a lady or a lady harassing a guy, that can be termed as what? Gross immorality. Absenteeism without leave or permission amounting to abandonment of duties. If you are the type that you are not going to office, you are not going to workplace, and there's no permission for you to stay at home, the employer can decide to what? Dismiss you. Lastly, gross misconduct. Just like I mentioned earlier, it's always important to specify what are those actions, what are those practices, what are those conduct that could bring about what? Gross misconduct. Very good example is what? Insubordination, habitual drunkenness, gross negligence, disobedience of lawful orders, and so on and so forth. All this can bring about what? Misconduct. Yeah. So it has been severally held by the court that an employee cannot be dismissed without being heard. Yes. So Section 33 of the Nigerian Constitution talks about freedom of fair hearing. Yeah, that's our fundamental right, fair hearing. So meaning that you cannot just, they cannot just, expect you to leave job. They cannot just sack you from employment without giving you the right to speak your voice, to hear your voice. It is not allowed. Any question on this, please? At this point, I want to make the floor open to questions. Thank you.
Hello, sir.
Go ahead. Go ahead.
No. I was just wondering if you were there. So far, everything
Yeah,
you've
I'm there.
said is okay.
Okay. So you don't have a question?
No, I do love
Okay.
contracts, so these terms are somewhat
Quite
familiar.
clear to you. So the reason why I didn't go into too much of detail is that almost all of us on this call are not yet a full employee. So discussing too much of analysis might make us not getting the point again. So, but it makes sense. Abdul Qayyum Gani, you are just joining us, right? Welcome. Welcome. You'll be introducing yourself later. You have to continue. So, any question from you, Comfort? Anyone? Any question? So we are good, right? Remember under contract, I discussed. I've always said that anything contract will always have beginning and end. The end is what we call termination. Yes, we want to appreciate how contract of employment can be terminated. Now, contract of employment can be terminated in any of the following ways. Compulsory winding up of the employer's company. So winding up of a company means cessation of a company when a company is brought to an end. When we get to company law, we appreciate this further. Now, if a company is brought to an end, automatically people working there, their employment will also come to an end. The solution of a partnership business can also bring about termination of employment contracts of persons working in the partnership business. A compulsory conscription of the servant during the time of hostilities or war could also bring about this. Now, what are we saying here is this? In the event of war, you are expected to support your company regardless. You will not follow your hostile nations. If you are doing otherwise, you are trying to bring about a conspiration against your company, then your contract can be what? Terminated. Prolonged illness of the servant. As an employee, if you are continuously falling ill and that has resulted to you not being active to work, then the employer might be forced to bring your contract to an end. Based on mutual agreement by the employee and employer, the contract of employment can be brought to an end. Mutual agreement can come in so many ways. It could be by performance, it could be by expiration of date, it could be by the completion of the project. Termination by the employer. The employer themselves can actually terminate your contract. This might not necessarily, this could be through dismissal. And lastly, as an employee, this is what is common now in Nigeria. You know the popular saying, japa, japa, japa. You can decide to resign. And every employment always have terms of resignation. We call that notice period. It could be 1 month, it could be 2 months, it could be 3 months. An employee can also decide to resign. Let's appreciate this past question. Let's appreciate this past question. So this is, I think I've discussed sources of law in this class. I'll display this question. I'll solve question number 1. I want you to explain to me your suggested solution on question number 3. I'll give question number D as assignment. So I'm solving A and B. Why C? I want you to give me your own view. So firstly, I will solve A, but I will still want to hear your opinion. Omega, a male employee of a big manufacturing company, disobeyed the order of his superior, Lotus, a woman. He had the same qualification with the lady who was employed before her, but the lady was promoted far above him. He refused to obey the instruction given by her for these reasons. An argument ensued, and another superior officer came and repeated the order earlier given by the lady, and the man, Omega, obeyed. The lady later reported the case to the factory manager, who recommended his dismissal because the company has zero tolerance for disobedience. Omega was dismissed. Is the dismissal justified? 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 Unmute yourself and speak. I will call you one after the other. But before then, I want anyone to volunteer themselves to speak. Is the dismissal justified?
Sir,
Rachel, I'm with you.
the
Why?
dismissal was actually justified because he failed to obey the rules and regulations of the company. And like you said, the company has a zero tolerance policy for disobedience. So it is actually justified.
Okay. Thank you so much for your view. Thank you so much for your view. Comfort. Comfort. Please give it a try. Is the dismissal justified? I will call you.
Okay, wait, sir. So I'm
Okay.
just sorry. Yeah, he said that it was given to him earlier on by another superior officer. Well,
Okay.
that means he already performed the duty given.
Okay.
And if he
Okay.
stated those reasons and they still dismissed him, yes, that was unlawful.
So where did you belong? APC, PDP, or which one? Where are you?
I'll go for the second that I just read because there's no point if he already repeated the order. If he already repeated the order that was given to him earlier, and he mentioned it to the superior that he had already performed this order.
Yeah. Okay. Let's hear other people's view. I don't know if you are right or wrong, but let's hear other people's view. Comfort, are you ready? Comfort, are you ready? Okay. Abdul Koyum, are you there?
Yes, sir.
What's your view? Is the dismissal justified? If yes, tell us why. If no, tell us why.
Yeah. The dismissal is justified because
Okay.
in the company, since there is for disobedience and she disobeys our instructions, so I think the dismissal is justified.
Is justified. Thank you so much. Is Comfort back? So, Abdul Koyum, nice one from you. Richard, honestly, your first answer was incorrect, but the second answer was correct. So I
Yes,
don't know
I didn't
why
read the question well. That's why I'm
Emota.
saying it.
So for the first time, I have someone that could reason around the line. Initially, if you are not careful, if you are going by the term, it did not follow the order, right? You can actually conclude to say that the dismissal is justified because that is what insubordination. I will mention insubordination as a gross misconduct, and that can lead to what? Dismissal. However, in this same case, you were told that a superior has given the same order and Omega followed it. Now, by following the same order given by the superior is a waiver to the initial insubordination.
Therefore, the dismissal was unjustified.
Where the dismissal was unjustified. Koyum, I hope that is clear now. The dismissal was what? Unjustified. Now, I've given you solution to that. So the C part of it, differentiate between unlawful dismissal and termination of employment. Differentiate between unlawful dismissal and termination of what? Employment.
Termination of employment is when an employee dismisses an employer. An employer dismisses an employee without formalities due to gross immorality, insubordination, while unlawful dismissal is when an employee has been wrongly dismissed.
Firstly, which of my screen can you see? Let me ask first.
The past question.
Okay. Secondly, I think there's a mix-up.
You think there's what?
A mix-up in your definition. What did you call unlawful dismissal again?
When the employee has been wrongly dismissed by the employer.
Okay. Without formalities.
No, that was termination of employment. Termination of employment is when the employee has been dismissed by the employer without formalities.
Okay, let me quickly help you. You've missed it up. Dismissal. An employee is dismissed without following formalities. While termination of employment is bringing an employment to an end following the due process, that is, following the due term of the agreement, whether expressly or impliedly. Remember, I mentioned notice. In every offer employment letter, there will be a notice period of termination for both employee and the employer. Is that clear now?
Yes, sir.
That is just the mix-up. So let me take it again. Dismissal is when an employer terminates the contract of an employee without following due formalities. That is, the employer feels or refuses to follow the laid-down procedure for terminating the employment of an employee. But for termination of employment, you are bringing the contract to an end following a due procedure, expressly or impliedly stated in the contract. Is that clear now? So, the B part, what are the remedies available to an employee for unlawful dismissal? Yeah, it is possible that an individual that is unlawfully dismissed can sue for certain remedy. And those are what we call available remedies available for an unlawful dismissal. I'm going to drop them one after the other on the chat now, on the chat box, so it's easier for you to relate with. my explanation. And I also send the solution to the platform. So now, let me know if you can see my chart. So the following are available remedies for an unlawful dismissal. I've identified just 4: damages, injunction, declaration, and specific performance. To sue for damages, in a simple term, is to sue for what? Compensation, consideration. Injunction can come in 2 ways. The court can ask the employer to carry out some functions or restrict the employee to deliver some certain functions. That is an injunction. Declaration. The court can actually declare the employee of certain rights, thereby the employer has no choice than to restate such an employee. Specific performance. This is an equitable remedy. When I say equitable remedy, the objective is to enforce what? Equality. Are you there? The objective is to ensure what? Equality. So meaning nobody can just unlawfully dismiss you without any due formalities. If that is done, you can actually sue to in common law or under the Nigerian law to enjoy some certain rights and obligations. Is that clear now? Any question on this, please? So we will be taking the D part as assignment. The Nigerian law has been tremendously influenced by English law, which constitutes the origin of a substantial part of our law. Secondly, Nigeria is a complex society, and this extends to our legal system. It is called the sources of law in Nigeria. So if you go to my previous videos, here I remember I did a recorded session. No one was present, and this is a classwork for you. Ensure you are punctual for class. The floor is open. Please ask your questions. Thank you.
Sir.
Please go ahead. I'm with you. Thank you.
Yes, sorry, could you repeat what you said about injunction and declaration?
Okay, fantastic. For injunction, it's an equitable remedy. It comes in 2 ways. The court can order you to do something or restrict you from doing something, right? An equitable remedy could come in the sense that the court can instruct the employer to pay a specific monetary consideration to the employee, or they can instruct the employer to carry out a specific service or support to the employee. Where the court sees it as just an equity, they could also ask the employee to stop to carry out some certain function to the what employer. That is injunction. It comes in 2 ways: to do something and to restrict you from doing something. Is that clear?
It's clear, sir.
Thank
Sir,
you.
could you repeat the declaration?
Okay. So for declaration comes in one process. So the one where the court can actually, for one reason or the other, expect the employer to disclose one or to discharge a certain term to the words employee. In this case, the employer has to come out to make a declaration of certain duties expected of them to the what employee. It is also an equitable remedy.
Thank you, sir.
Yeah, you are most welcome. In the absence of no question, it's a pleasure
Sir,
having you
sorry,
guys around.
one last
Okay,
question.
go ahead.
Are we still going to have this class the same time next week? Because you know, next week Sunday is Christmas.
We shall communicate with you guys.
Okay.
That's a good question. Yeah, we'll take it to the management and confirm. Thank you. See you in our next class, maybe next week or upper, but I'm sure I will likely do a recorded session. Thank you.